A 9-0 victory at the Supreme Court for President Trump and our client who was a party to the case, the Colorado Republican State Committee. That includes then all three liberal justices of the Supreme Court. 9-0 that you cannot remove President Trump from the ballot as a state actor, whether that's a Secretary of State or through a court system, that this has to, the only way that could happen is if Congress were to pass new legislation giving some kind of power to the 14th Amendment, legislation that does not exist at this time, and legislation with the divided Congress I don't see existing at any time in the near future or ever. It was a full vindication in the sense that for future presidents as well, Dad, yes. Which is so important here. And though a lot of people are focused on the Trump side of this, but that future presidents won't have to worry about what he went through and what we went through with all these states across the country, having to battle back and spending significant resources just to make sure people would have the opportunity to vote for him. Not that they would definitely vote for him, but that he would be on the ballot.
No, the issue was, can a state, on its own initiative, remove a candidate from running for president from their state ballot? And the answer by all 9 justices, and I want to reemphasize this, all 9 justices said, no, you can't do that. Justice Roberts writes, in the opinion, all 9 members of the court agree with the result. Justice Barrett writes in her concurring opinion, all 9 justices agree on the outcome of this case. That is a message Americans should take home. Then the 3 concurring justices, which also agreed with the opinion, Sotomayor, Kagan, and Jackson, said to allow Colorado to take a presidential candidate off the ballot under Section 3 would imperil the framers' visions of a federal government directly responsible to the people. So I want to send a message to the naysayers about the institutional credibility of the Supreme Court, to those that have talked negative about the Supreme Court of the United States or have said it's become a political partisan institution. There were pundits this morning saying this is going to fall down to some kind of political lines, Republican nominees and Democratic nominees. None of that happened. On a case of great magnitude, this is a tremendous victory, by the way. Not just a victory for President Trump, but a victory for our electoral process. I would say it's the most significant case like this that we've ever handled. And to have all 9 justices issue what is called a per curiam opinion, that means the court is speaking. It's not a justice. It's up on the screen right now. It says per curiam, the court, through the court. That sends a very powerful signal. We're going to break all of this down in the segments coming up. But I got to tell you something, folks. The battle, this is a great victory, and I don't want to take anything away from it. The battle has really just begun. First, we got to go in and get some states to stop. We've got 3 cases we've got to get handled. But it is a resounding victory at the U.S. Supreme Court. As I said, unanimously ruling in our favor to stop the left's attempt to ban President Trump. We'll get into their reaction in a minute. This is one of the biggest Supreme Court victories in the ACLJ's history. We represented the Colorado GOP in the case, winning a massive victory for the Constitution, but also we protected the right, everyone's right to vote for the candidate of their choice. The only way that we get these victories is through your support. But the legal work does not end here. First, the fight continues as we now have got the 3 remaining cases. We got to go back to court, file motions to dismiss, and get those dismissed. And then immediately we are involved in the presidential immunity case, which is another attempt to disqualify President Trump. That's also at the Supreme Court. That's going on right now. So we must defend the Constitution once again, and we need your support to do it. Go to ACLJ.org and have your tax-deductible gift doubled during our Life and Liberty Drive. Jordan?
And folks, this is, again, it's a critical time to support the work of the ACLJ during that Life and Liberty Drive. Again, to double the impact of your donation, to stand with us. This is an opportunity. It shows you can still win 9-0 when you're on the side of the Constitution, and it's clear, even when the left tries to come against you in their courts, you can be victorious. And that is why you always fight for your country and for our elections and for our system of government. Go to ACLJ.org. That's what we do, and donate today. Some people think champions are born, that it's a title that requires something only a handful can ever possess.
There are times in our lives that we are called, every one of us, to step up and serve a cause greater than ourselves.
Even when the loudest voices in the room say it's wrong, that it can't be done. It can be a difficult stand, but it's one any of us can make, including you.
You can be the change. You can make that difference.
You can be a champion. We cannot do what we do without you.
By becoming a monthly donor, you can become a champion of life.
A champion of liberty, a champion of freedom.
Please join us. Become an ACLJ champion today. All right, welcome back to Sekulow. A huge 9-0 victory, unanimous decision at the U.S. Supreme Court. The ACLJ, representing as a party the Colorado Republican State Committee, won 9-0. The Trump campaign won 9-0. You cannot have states using the 14th Amendment, Section 3, to decide when they want to remove a candidate from either the primary or the general election. Now, it was a per curiam opinion. And, Dad, you talked about what the per curiam opinion was, which was by a decision of the entire court in a unanimous agreement. But I know people are out there thinking, I've even seen it on Twitter, is the fact that it's not signed take any power away from it?
No. In fact,
people want to know that.
I think to the contrary, and Andy and I were talking about this before, per curiam means simply through the court. You had the rare situation where all the justices were speaking with one voice. And the one voice that they spoke with is because the Constitution makes Congress, rather than the states responsible for enforcing Section 3 against federal office holders and candidates, we reverse. In other words, the states can't do this. So I think to the contrary, I know some pundits are saying that, but Andy, in reality, the fact that it's per curiam sends a more powerful signal.
Oh, absolutely does. Per curiam, as Jordan said, is a Latin term that means through the court. It's not authored by any particular justice or the chief justice, but it's put together by the input of all the justices, and I think it gives it added impetus and added influence and added persuasiveness in that no one justice has spoken, and the court was not divided. It was a unanimous decision per curiam through all the court that the federal officers owe their existence and functions to the united voice of the whole, not a portion of the people. Powers over their election, I'm reading from the opinion, and qualifications must be specifically delegated to rather than reserved by the states. It's not a state power, it's a congressional power.
This was a federalism issue here, and we're going to get into what that means, but I want to make something very clear. To those pundits that were saying the Supreme Court is a political institution or it's falling on party lines, this was unanimous as to what the role of the states were here. And the role of the states in this were nothing. The states cannot seek to remove a candidate, disqualify a candidate from public office for president based on the 14th Amendment, Section 3, which, as we put in our brief, which was really utilized by the court, this idea that the 14th Amendment would be an empowerment to the states, when actually the 14th Amendment, which was done during Reconstruction, Harry, was to limit the states. So the court, all 9 justices, got that part completely right.
Precisely. So states do have power to disqualify, but only with respect to state as opposed to federal offices. And it's clear beyond question that the presidency is a federal office. And so this case raised the question whether the states, in addition to Congress, could enforce Section 3. The Supreme Court answered that question unanimously. The answer is no. It's up to Congress.
It's interesting, Cece, that, and I'm going to go to Justice Barrett, she wrote a concurring opinion as well. And a concurring opinion means the same result, some different rationale, but she made a statement here that I think is very important for people to understand. And this is going to this politicalization issue. All 9 justices agree on the outcome of this case. This is the message Americans should take home. Let me read that again. All 9 justices agree on the outcome of this case. That is the message that Americans should take home.
Yeah, it's very encouraging. I think we were encouraged even when we heard the oral arguments that all the justices seemed very focused on the language of the 14th Amendment. And even in the opinion, it says, the 14th Amendment on its face does not give this power to the states. And so They very much followed the Constitution, and we saw that from the left and the right. So I know a lot of people are saying this is political, but I think it's the exact opposite. This is not a political opinion. This is an opinion that actually follows the Constitution.
If you have questions on this and like how this is going to impact the voting, I mean, the Super Tuesday is tomorrow, or what all of this means when you get a 9-0 opinion like this, and then you get these concurrences that maybe they didn't have to go as far as they did, but you know what, this does it settle the issue for the future? We want you to call us. There's no bad questions on this. I mean, these are complicated issues, and obviously you saw the timing it took for the Supreme Court to put together what was a very short opinion. I mean, I was expecting, because they were taking so much time, like hundreds of pages, but it was very tightly worded, very specifically worded. This is one that we'll have it through links at ACLJ.org. I've tweeted out the link as well. When you have time today, I mean, you could read through it, and it's not like what I was expecting because of the time delay.
Very little on the issue of insurrection.
Almost.
They referenced that was the allegation made in the complaint in Colorado,
Yeah, I think
but that was it. It was the law, which is exactly what we argued in our brief. In the second half hour of this broadcast, we're going to go through and lay out some of the things we argued in our brief that actually appear in the opinion, including cases that we were the only group that cited. And we were a party to this on the Colorado GOP. So that's the good news there. We are already getting calls in. But I want to, again, if you want questions on this, and like Jordan said, there is no bad question here. 1-800-684-3110. I really want to explain this to you. Now, this is different than the immunity case, which is currently pending. We're working on that brief as well, because there also impacts not getting into becoming president, but operating as president. And these are huge ramifications for our country.
Now we've gotten over the hurdle to actually becoming president. If being
now
able
you're
to
the president,
be on the ballot.
Now you could be sued, you're criminally indicted for decisions you make that are your official acts as president. That's the next challenge.
Yeah. All right. I want to go to the phones at 1-800-684-3110. John in Boston on line 1. Hey, John.
Hi. Good afternoon. Thank you for taking my call. I wanted to ask the obvious question: how this affects the judge's decision in Illinois to deny Trump on the ballot there.
President Trump will be on the ballot. Let me play this. This is from Eli Honig on CNN this morning. So, John, you will have him on the ballot, bite 38, and your vote will be counted.
The bottom line here, though, is this is unanimous. It's not up to the states. And another really important point, this is it nationwide. All the 14th Amendment challenges, Maine, Illinois, the dozens of others that had failed or were still pending, it's over. The 14th Amendment will not be applied to Donald Trump. He will be on the ballot in every state where he wins the primary.
So now the question is, we've got these other cases that caller was talking about. We have to go back in on those, file motions to dismiss. You hope these judges don't come up with some creative attempt to try to keep jurisdiction. I don't think that's likely here. But let's talk about the big takeaway here. And I want to get everybody's view on this. I'll start first with Andy. What's the big takeaway? What do you see as the big takeaway here?
The unanimity of the court. That impresses me. I'm looking at the concurring opinion of Justices Sotomayor, Kagan, and Jackson, the three liberal members of the court. And here's what she said. Sotomayor, in writing, said, allowing Colorado to make the decision as to who to keep on the ballot for the presidential election would create a chaotic state-by-state patchwork at odds with our nation's federalism principles.
Yep.
That is enough to resolve this case.
And the chaos, CC, is something we pointed out to in our briefing, both at the petition stage and at the merit stage.
Yeah, absolutely. And again, I'll go to the oral argument because I think that was so telling of this opinion that the justices focused, and even the liberal justices focused on the chaos, as Andy just pointed out. That you get, a single candidate would be declared ineligible in some states, but not others. And that just would cause complete chaos and actually nullify the votes of millions of people. It could have that effect.
Harry, and the fact that it is unanimous, what's your takeaway on that part?
Well, I think to go back to Andy's point, number one, it removes chaos. Number two, it removes basically instability within the system. It's important to keep in mind that individuals in Texas and West Virginia have proposed either legislation or judicial action to remove President Biden from the ballot on the other side. So what the Supreme Court has done here is that essentially they've eliminated the 14th Amendment as an avenue for removing any candidate from the presidency. That is a step forward with respect to democracy. The Supreme Court opinion defends democracy.
All right, I want to hold up for our ACLJ members, ACLJ champions, people that support the work of the ACLJ. In my hand, for our radio audiences, it is 6 inches thick. This is the paperwork, and it's actually 3 times this, because this last volume, which is about an inch thick, there are 4 of. I just can't hold them all. This is what we filed in this case to get this victory. This is the amount of legal work that went in. So we want to encourage you to do something. This is, as we said, a resounding victory for the ACLJ at the Supreme Court, unanimously ruling in our favor, keeping the former president on the ballot. It's one of the biggest Supreme Court victories, frankly, we've ever had, certainly the biggest on election integrity. We represented the Colorado GOP in the case. Of course, we had cases all over the country. We protected your right to vote for the candidate of your choice. The only way we get these victories, though, is with your support. But the legal work does not end. We've got that immunity issue we're fighting now. So once you're in president, can you then be, criminally prosecuted for the official acts you take? The answer has to be no. So we're fighting that. We've got to get dismissed the remaining 3 cases, which we will. And then again, as I said, the immunity case. We must defend the Constitution once again, though, to make sure the president has the full authority to act without having a battery of lawyers for every decision they make. Go to aclj.org and have your tax-deductible gift doubled during our Life and Liberty Drive. If you can make that a monthly gift, by the way, you become an ACLJ champion.
Yeah, and folks, again, we need you at the tip of the spear on these issues at aclj.org to become a champion again. You're standing with us in all of these battles to protect your right to vote and to be involved. aclj.org.
Life, in its essence, is built of moments, experiences, and connections that define our existence. It is a journey filled with opportunities for growth, learning, and the formation of relationships that enrich our souls. Life is precious because it offers the chance to make a difference, to leave a mark on the world, however big or small. It is a gift that demands our attention, care, and reverence, encouraging us to live fully, love deeply, and leave a legacy of kindness and compassion for future generations. At the ACLJ, we choose life.
All right, welcome back to Sekulow again. A 9-0 victory for our client, a party in this case at the U.S. Supreme Court, the Colorado Republican Party, and their chairman, Dave Williams, who's been working alongside our team throughout the beginning and has done a great job, again, assisting our team throughout this and taking those phone calls throughout the process, all 3 levels of the Colorado state court system, and then ultimately to the U.S. Supreme Court. Dave, thanks for joining us today. Just first, your reaction to this kind of unanimous decision at a time when you don't see a lot of unanimous decisions when cases involve either Donald Trump or politics.
I think this is great for the country.
Yeah.
The fact that all 9 justices, regardless of who appointed them, came to the same conclusion really speaks to how we as a society should not be interfering with the people's right to vote for the candidate of their choice. And that's reflected in the decision. I couldn't be happier for your work and the work of the team to make this a reality.
Dave, you got, obviously, it was your state that was the one front and center on this, and it was your party that was the one harmed. And I think what people need to understand in our representation of you before the Supreme Court and then even before the trial court and the Colorado Supreme Court, it was your party position of who the nominees would be on the ballot. And that your Secretary of State was basically telling you, as the party, you can't do it. You can't put on the person you wanted on that ballot. But this time it was Trump. Next time it would be somebody else.
Right. I've said this from the beginning. I even expressed this to you and the team that while we certainly agree that Donald Trump had a right to access this ballot, that this case was bigger than Donald Trump's interests. This had to do with the party's ability to nominate the candidate they thought best to represent them on the general election ballot. If they can do it to someone like Donald Trump, then they could certainly do it to other candidates in the future. And that was something that we wanted to avoid. And thank God that this ruling did just that.
I mean, Dave, it kind of came like at the last minute because you've got a lot of Super Tuesday voting going on in the state where we live in, where you are. I mean, that people, again, I think they were going to come out. A lot of people early voted too. And in most states, it was stayed anyways if you did early voting. The state that didn't do that, that'll be overridden now because it won't matter. But again, I think it'll give people a sign too that now they know 100% it's worth waiting in line. Their vote's going to be counted if they decide to vote for Donald Trump, and his name is going to be there on the ballot. It's not going to be tossed aside.
Right. I mean, that was a concern all along. Our Secretary of State, who sided with the petitioners and was helping them in their case, was more than willing not to count those votes. And there was a bit of a question on what exactly would happen if the Supreme Court didn't come back with a ruling that was favorable. Now that's all avoided. Everyone can vote for Donald Trump and support the presumptive nominee. And it's on to November. So I'm just happy that people have clarity on this. And more importantly, all the other challenges across the nation should be put to an end with this ruling. And that's just good for our democracy.
No, the case affects the entire nation. So there's 3 other cases we're actively involved in right now. We'll be filing motions to dismiss and get those resolved. But I want to follow up, Dave, on what you said. This is from the opinion. The result could well be that a single candidate would be declared ineligible in some states, but not others, based on the same conduct and perhaps even the same factual record. So what all 9 justices said was this was going to result in this chaotic approach. And you were seeing that chaos even in Colorado as it started.
Yeah, this was a concern that we all discussed from the very beginning, even when we intervened immediately at the district level, that if this is allowed to stand and it gets this far, you're going to see other states removing Donald Trump. And then if it is allowed to stand, then you're going to see the opposite party, my party, potentially look at removing Joe Biden from the ballot, which just isn't good policy. The people should be deciding these elections, not justices or judges in a courtroom.
Actually, Justice, it's interesting you said that because, Dave, the Justice Sotomayor in her concurrence said, this, let me read it because it's exactly what you just said. Allowing Colorado to do so would, we agree, create a chaotic state-by-state patchwork at odds with our nation's federalism principle. That is enough to resolve the case. And she goes on to say that by allowing this, you would have basically taken away the right to vote. So, again, let me just say a huge thank you for all of us and for the American people, for the Colorado GOP and for you for standing up right in the beginning of this when this thing started. We were the first petition filed with the Supreme Court of the United States to get this stopped because of your organization's involvement. Dave, thanks for being with us and thanks for your hard work on this.
Well, thank you. Happy to have done it with you.
Thanks, Dave. And again, let's go right to the phones. 1-800-684-3110. Let's go to Ann in Omaha, Nebraska on line 1. Ann, welcome to Sekulow. You're on the air.
Hi, thank you very much for taking my call. So my question is, I read an article that was published in The Atlantic, but I'm reading it on Fox, that says the Democrats could vote against certifying Trump if he's elected, based on whether or not the Supreme Court was clear about whether he was eligible, that's the word, eligible to run for office, that they could decertify him if he was elected.
Yeah, so the answer to that is no. I mean, I did see, by the way, some tweets to that effect, too. Look, they're going to try to do anything they can to circumvent this. So that's why we got to be very vigilant here, folks. Anytime you win a Supreme Court case, thank you. Thank God. Thank you, our supporters. But you've got to be vigilant because they're going to try stuff. Now, decertification would be a very dangerous move. You talk about election interference. What they've indicted people, for questioning the 2020 election. And now, in this situation, to decertify or not certify the candidate, Harry, would be unprecedented, really.
It would be, but I wouldn't put it past the Democrats to attempt to do so because the Democratic leadership is remarkably inconsistent with respect to legal principles. So they claim to support democracy. They claim that they are defending democracy by going after Donald Trump, but they are nonetheless willing to use the same tactics that they accuse the Republicans of if it achieves a particular political objective. So I think at the end of the day, we should be wary and we should be prepared that the Democrats who suffer from the Trump derangement syndrome will use any means possible to go after Donald Trump.
But let me quote Justice Sotomayor, Kagan, and Jackson. They wrote a concurring opinion. They agree with the result. They wrote a concurring opinion. To allow Colorado to take a presidential candidate off the ballot under Section 3 would imperil the framers' vision of a federal government directly responsible to the people. That's what they said. So to the answer to that question is no, Congress can't do this. Folks, but we've got to fight because they're already putting their plan in place, Jordan. That's why we got to really fight here.
That's right. I mean, you hear all these different ways they're looking at it. I mean, there's other court cases going on. Like you said, the immunity case that we're working on right now, filing that brief again, which is, again, very difficult cases at the U.S. Supreme Court. I mean, time and time again, we are seeing this.
And, you hear commentators say this is a win for Trump, but it's actually a win for our constitutional
100%.
republic. Because we, the voters, and whether you vote Republican or Democrat, we are the winners that we actually get to vote for the candidate of our choice, and that a state cannot decide that. And, they, in this opinion, they point out that even historically, when you look at the history, states have never enforced the third section of the 14th Amendment against federal candidates. So it follows the Constitution. This is a good opinion.
Folks, we're in our Life and Liberty Drive. We're on day 4 here. And this was a resounding victory that would not have happened without you. Because, as I showed you, I'm holding it up again. I want you to see this, folks. This is lacking about 6 inches more of legal work that went in a 1-month period. Thousands of pages of documents. Printed, sent to the Supreme Court of the United States because of your support of the ACLJ. It is a huge win. It was the left's attempt to ban a presidential candidate. This time it was Donald Trump. Next time it could be somebody else. I think it's fair to say this is one of the biggest Supreme Court victories in the ACLJ history. A law professor that my alma mater calculated that we now have 25 cases at the Supreme Court at the ACLJ during our history. We represented the Colorado GOP. You just had Dave Williams on, winning this massive victory. We protected your right to vote for the candidate of your choice, and the only way that we get these victories is with your support. Now, here's the thing. Our legal work does not end. First, we got to get these other 3 cases dismissed. We're going to move to dismiss those. But now we've got the legal issue of what happens to a president when they're in office. Can they then be criminally prosecuted for the decisions they make that are part of their official responsibilities? That is now at the Supreme Court of the United States. Our brief on that one is due this month. So the fight continues. So we must defend the Constitution once again. Your support is critical. Any amount you donate to our Life and Liberty Drive is matched. It's doubled. Your donation is doubled at aclj.org/life and liberty. And if you can become a monthly donor, you become an ACLJ champion.
We've got 3 remaining cases to get this dismissed, Dad. In addition, a new fight's been launched on the immunity issue. We've got to defend the Constitution again. We need your support. Go to aclj.org. Have your tax deductible gifts doubled during our Life and Liberty Drive because, again, this is a wonderful victory. I don't even think we've seen the ramifications yet from the left and on the 9-0 victory. They're starting to react in like tweet form. This was big, but there are bigger cases even coming ahead. Support our work, aclj.org.